Good evening, everybody. It's really great to see so many of you here on a rainy evening in Geneva. My name is Anne Saab. I'm an assistant professor of international law here at the Graduate Institute, and it is an absolute pleasure and honor to be able to moderate this conversation this evening about international law and imagination. Most of us, or most of you, I would assume, when we think about international law, we don't immediately think about imagination. And we don't tend to see lawyers, including international lawyers, as particularly imaginative beings. But as the event's description notes, law might in fact be the most powerful school of imagination. Lawyers or jurists, if you want to take a broader term, may in fact be inventing the real that they deal with. International law doesn't exist out there for lawyers to simply discover and apply. International law has to be created, and when circumstances change, international law has to be recreated. And any creative act requires imagination. So what is international law, and what might international law be? So let me introduce today's speakers. I will try to, so I'm moderating, but I will really try to limit my own speaking because I'm much more interested in hearing both gentlemen on my side what they have to say about imagination. So I have Professor Gerry Simpson, who's chair of public international law at the LSE, to my right, and Professor Andrea Bianchi, who is professor of international law at the Graduate Institute here to my left. Now, I could go on and list both speakers' very impressive achievements in academia, but if you are not already familiar with their work, it is quite easy for you to become familiar with their work. So I am not going to spend a lot of time on introductions because I, for one, am much more interested in hearing what Professor Simpson, Professor Bianchi have to say about imagination. And I should state also that these are the two of the most imaginative minds in international law. So how this is going to work is we've come up with quite a list of questions that I'm going to pose, and then I'm going to let Professor Simpson and Professor Bianchi have their say on these questions. I'm not sure if we're going to get through all of these questions, and that doesn't really matter because we're more interested in the answers than in the questions. So let me begin. The first question is about definitions. Lawyers like definitions, even though there are many flaws in defining things. But I think it's a good place to start. So we are talking about international law and imagination. So what do you understand under imagination? What is imagination for you? What is imagination in international law? And what is not imagination? So what is the other of imagination? That is the first question.
Well, I think we should circle that question a bit, or at least circle the answer to that question a bit. So the thing about speaking on a topic is that it's like buying a new watch. You suddenly see everyone's wearing a watch, and you look at their watches, and over the last 24 hours, I keep encountering imagination. So I was in the library for about 10 minutes there, just preparing some thoughts and so on. And I looked up and I saw James Boyd White's book, The Legal Imagination, sitting right next to me in the library. He has various definitions of legal imagination, but one thing he does say is that every lawyer lives by her imagination, the power of her writing and her imagination. So one level, international law is an imaginative enterprise. But you said something about imagination and international law being an unlikely coupling, and I think that's also true. I mean, in recent years, just to give a bit of background to the direction that international law seems to be going in here, people have started to speak about topics that didn't seem very closely related to international law. I've noticed this in the last decade or so. People are putting topics together that don't seem to belong together. So, I mean, I've been at talks recently on paper shredders, on air conditioning, on all sorts of topics you wouldn't think have any relationship to international law. In fact, I was telling a colleague of mine, telling a friend of mine in the United States that I was speaking on sentiment at NYU, and she said, "Is that even an international law topic?" And I discussed how international law was sort of broadening its horizon and so on. And we took a train up to upstate New York, and we bumped into Nathaniel Berman on the train, an international lawyer some of you will know. And she said to him, "What are you doing?" And he said, "I'm off to Bard College to give a talk on international law." And she said, "What's the topic?" And he said, "Anger." So international law is much more expansive than it's been for a long time, and it can quite readily, I think, accommodate something like imagination. So I think any definition, in other words, runs two risks. One is tautology, and the other is banality. I mean, as soon as you begin to define imagination, you start using terms like vision or imagination or the power to imagine or so on. So, to go back to my initial point, I think probably the best way to think about imagination is not to come at it too directly, to take the sort of Emily Dickinson approach, success in circuit lies, and sort of approach it from the side somehow.
Well, I'm notoriously not good at definitions, so I'm not sure I'm the one who's going to solve the riddle of the definition. I quite agree with what Gerry said. Then I would invite you to reflect on this very slippery concept on the imagination. And as a concept, this is not unique to law. I mean, imagination is a general category by which we try to bring order to how we conceive of the world, how we see it. But it's a very slippery concept, the contours of which are quite slippery. And I think that, moreover, I mean, it's one of those concepts that travel across disciplines, and so they get a little bit twisted. They have to adjust to different settings and so on and so forth. But by way of illustrations, by way of example, recently I bumped into this in a piece that it appeared last week in the London Review of International Law, a review who is familiar to Gerry because he's the editor-in-chief. I was very happy. On the unbearable lightness of international law. And I made a quote quite inadvertently at the time I wrote it, about Robert Musil from the book A Man Without Qualities. And it's not a definition of imagination, but it gives you an idea of what imagination may be for. And Musil says that imagination can help widening the range of options, keeping a sense of possibility. And that's a great insight, I think, because it makes you understand this concept as a tool to open up something, a perspective to widen the range of options. So, however difficult for me is to work with definition, I think that generally imagination is that kind of intellectual and emotional capacity to envision and to engage with not just the world, but also alternative worlds. And Anna asked about what's the other of imagination. To me, and I'm quite opinionated about this, the other of imagination is dogma. Is the rigidity, is the boundedness, is the incapacity to go beyond the limits of what the real world offers to you. It's the acceptance of the established boundaries of the established orthodoxy. So dogma is for me the enemy or the other of imagination.
Yeah, absolutely.
Yeah, I agree with that. You mentioned incapacity. There's a nice quote from Nabokov where he talks about the capacity, the child. I know you're going to ask about childishness at some point, so I'm slightly getting ahead of ourselves here, but he talks about the childlike capacity to wonder at trifles. Mm-hmm. And I rather like that as a sort of working definition of what imagination might be. So the things that we might imagine are slightly trifling and unimportant might turn out to be much more important than we imagined. And so I've always been interested in the micropolitics of international law, how people actually behave at conferences and how they behave in relation to their home help, or how they behave outside the conference hall. So people who are just busy giving a seminar arguing against hierarchy often turn out to be very hierarchical. There are all sorts of funny juxtapositions start arising in relation to the micropolitics. So noticing these trifles with a sort of sense of wonderment might be a definition of anger that might be useful. I do slightly worry that I do slightly worry that we use it to affirm work we like. So here I'm channeling my countryman David Hume, who would have thought that our use of words is just a way of affirming certain phenomena out there in the world. So we might as well just say, I like this and I don't like that. But we can't say that because the seminar lasts for an hour and a half. So we dress it up in a lot of normative propositions, one of which might be imaginative. It's a bit unusual for someone to come along and say, I found that lecture imaginative, I didn't like it. It's not impossible. Or what an utterly unimaginative seminar the lecturer gave, I loved it. But it's just about possible. So I began this thing I did on imagination recently with a description of these two prizes that the American Society of International Law gives out each year. One is for the best, I don't know what it is, it used to be the best sort of technical, functional book in international law that year. And the other was for the best piece of creative scholarship in international law. And my colleague, Hilary Charlesworth at Melbourne, told me once that prize was given to people who were making it up themselves. And I like this idea that somehow there was a prize in international law for just making it up. But the fact is that both prize winners, and again, this goes back to the point that's already been made. Both prize winners are making it up. One is engaged in a very overt imaginative practice, a sort of visionary, if you like, imaginative practice, something more akin to a sort of literary sensibility being applied to international law. But the other is also engaged in imagination. I mean, this goes back to Anne's point at the beginning. As soon as an international lawyer describes the world, even the most hardcore, technical, functional positivist is projecting a world or projecting a vision of the world or engaging in an act of imagination. It's just that very often they imagine that they're not engaging in an act of imagination. So it's a kind of double act of imagination that they're, in fact, engaging in that particular case. So I think these two prizes, in a way, reflect these two international laws, a sort of sublunary international law, which is involved in the assembly of material, sociological material, consensual material, state practice, whatever it is, that sort of international law, and then the more sort of starry international law. I mean, I'm reading Nietzsche on starry friendship at the moment. So this is the idea of an international law we might aspire to that seems further away from us than that other international law. So I mean, that might be one way into this. And just one final point on this. Maybe that's the difference between kind of literary and political forms of imagination. So in one sense, we require political imagination to be fairly closely grounded to already existing political practices. Very often, the sorts of visionaries that the populace admires, the sorts of visionary who situates her political practice in an already existing politics. Whereas when we talk about literary imagination, I think we tend to imagine, or we tend to think about pieces of literature that are sort of utopian, possibly science fiction, certainly are capable of imagining a whole completely different universe somehow. So these are sort of, I think, ways into the problem of imagination. I was reading the London Review of Books in a lovely little cafe just down the road here on Rue de Lausanne, and imagination came out. This goes back to the first point I made. I keep seeing imagination everywhere. So there was an essay on the Australian novelist Gerald Murnane, and he talked about how he disliked imaginative fiction. He associated imaginative fiction with people like Norman Mailer, funnily enough. Mailer imagining himself to be various figures and writing from that perspective, or imagining he could say something meaningful about, say, Gary Gilmore, a person on death row. Whereas Renan was more concerned to describe the world he already inhabited. So it's often said that the reason Emily Bronte was a sort of world historical novelist is that she imagined a world she couldn't possibly have known. This is perhaps the mark of the genius, but this is not a seminar on genius, is it? It's
Yeah, and I think that if you were to be introduced among the two most imaginative lawyers until recently, this would have been an offense. So I'm sure that was not Anna's intention, but...
Well, actually, that's what I was thinking when you said if your lecture would be described as imaginative, that would almost always be sort of a positive thing. But I would also, and maybe that's also a gendered thing. But if I would give a lecture and it would be called imaginative, I think I might not necessarily take it as a compliment, because I would think, was it good enough? Was it sort of professional enough? It was too imaginative. But yes, I absolutely meant it as a compliment, just to be super. Okay, so the next question I want to ask really latches on to something that Andrea said about in sort of not necessarily defining imagination, but using other words rather than a strict definition. Imagination as widening the range of options. And sort of Gerry writes something similar. So imagination involves a capacity, or at least willingness, to stand at a distance from the current orthodoxies. So it's really so imagination as being related to what Zizek calls the coordinates of the possible. So keeping open a range of possibilities. So my question would be whether you can give some examples of successful use of imagination in this understanding of imagination in the history of international law. So how has imagination been used to keep a range of options open?
Well, if I am to have a go at this, I think one can think of a handful of very conspicuous examples of imagination. I think the first one I can come up with is something that probably very few people think about nowadays as an imaginative exercise, but I'm thinking of the UN Charter. I'm thinking of the UN Charter as an incredible vision put forward by a handful of people at a time when the fate of the war hung in the balance. So we were in the middle of hostilities, and the Nazis had a fair chance of winning the war, and yet somebody had already started thinking about what the world might look like or should look like after the war. I think it takes imagination for this. Is it political imagination? Is it just a daring thinking what at the time was barely thinkable? I don't know, but I take these people to be visionaries in the sense of having the capacity of engaging with a political project, which was not very easy to envision at the time, because the first encounters in which the Allied powers started sketching out that kind of future world order really date back at a time when it was not clear what would have happened with the war. And then there are others examples to begin to stay within the Charter. Also, the idea of peacekeeping, I think, is in many ways very imaginative because it doesn't have a very solid basis in the Charter. As we all know, states should have made bilateral agreements with the Security Council to provide troops. This never materialized. At some point, Security Council came out with this idea of peacekeeping. It takes imagination. I'm not talking about the success of the enterprise. That's not the point. I'm talking about the capacity of relating to the world in an imaginative fashion. And then perhaps the last example I would like to make, one can go on and on with this, but I wanted just to put forward some very practical illustrations. As an act of imagination, Um, maybe it's too far-fetched, but I like to look at it as an act of imagination. I'm thinking of Filartiga versus Peña-Irala, the judges sitting in the Second Circuit, the Court of Appeals of the United States in New York, 1980. And the claim that they uphold about this case, which had been brought before federal courts in the United States about the wrongful death of this child. And then they retrieve these very old statutes that dates back to the first Congress of the United States, 1789, that had been passed by Congress for a completely different reason. And they use it. They use it to allow, for the first time, a civil suit before the federal court for a tort, the wrongful death of this child in violation of the law of nations. I think that's an illustration of legal imagination, of having the capacity to use an instrument and to adjust it to different needs. And as you know, the Allen Tort Claims Act, because that's the statute we are talking about, has been used since as a major tool to litigate human rights and environmental issues in the United States. So I think there is definitely a plethora of examples of legal imagination from the real world, from concrete operation of day-to-day life.
Yeah, examples are dangerous because you offer an example and then someone in the audience says that's not very imaginative. They'll say that the UN Charter was just a bunch of diplomats coming together to impose a hegemonic world order on us, something like that. I mean, I happen to agree with Andrea that the UN Charter was a visionary moment. I just go back to your point about gender, though. I thought that was interesting. I gave a talk in New York on this talk on sentimentality, and at the end of the talk, someone put their hand up and said, "If I gave a talk like that, it would be career suicide." It was actually a young man. It may be a youth seniority thing. I don't know, but there's something in that. There are certain sorts of subjects you're just not permitted to go very close to as a younger academic. Actually, let me just correct that. When I was a younger academic, I wrote in what I imagined to be quite a visionary way that was utterly amateurish. I was like sort of mescaline addicted Aldous Huxley in that period. So 2 or 3 articles that are barely readable, but quite imaginative. And then I learned to write like an academic, and it became very tendentious and a bit austere. I began to write as if I was a Supreme Court judge in the United Kingdom, in that sort of mode. I thought I can establish myself as a lawyer by beginning to think as a lawyer. Now, I don't know whether that was a willful act of anti-imagination or not. And then I sort of found a voice, but I think finding a voice may involve doing the sorts of things that would be too risky for other people to do. I don't know, but I thought it was a provocative point. So here we come to this idea of getting close to the definition of imagination. So one relationship is the relationship between imagination and utopia. So, and this goes back to your examples. Sometimes what we demand of imagination is a form of utopian politics or a highly visionary literary enterprise. And if we fall short of that, we end up sort of shaking our heads and going, "Oh, that's just the world as it is." So what I liked about your examples were that they didn't go into this sort of utopian afterlife of international law. They stayed fully located in the actual, or what you called at the beginning of the conversation, the real. A case before a district court in the United States, and ultimately, I think it went to the Court of Appeal. At least was a Supreme Court case, Philadelphia Court of Appeal, and the UN Charter, which is partly a description of the world we live in. So this relationship between utopia and imagination is quite important, and there may be 2 different ways of doing imagination in international law. One that is sort of explicitly utopian projections into imagined futures, and and one that's more sort of situated in a current politics. Now, I'm going to invoke Philip Allott as an example of the former, though if Philip was here, he'd probably want to be in the latter camp. But his book, Eunomia, seems to me to be a highly imagined sort of neo-Hegelian construct of a possible world to come, which can only come through a major sort of revolutionary transformation in our ways of thinking and our language used to describe the world and that way of thinking. So I think this would be an example for me of at least explicitly utopian imaginative international law. But I suppose in the institutional realm, well, you have to say the League of Nations. I think, given that we're here, I think perhaps I've been too influenced by 3 novels about the League of Nations rather than the actual League of Nations in saying that. But I was very, very engaged for a few years by Frank Moorhouse's trilogy on the League of Nations. The first of which is called Grand Days, and it describes a world that's just so vibrant and interesting and diverse and plural in Geneva in the 1920s. But it's partly related to precisely that, the atmosphere and mood in Geneva at the time, but also partly related to this grand experiment that was taking place in this city, an experiment that we might say the UN Charter makes good on, or we might say it dilutes slightly. Or the UN Charter is a sort of pragmatic example of the League of Nations. So let's put the League of Nations in the imagined, more utopian side of the spectrum, and the UN Charter in the less utopian side of the imaginative spectrum, but describe them both as acts of imagination. And then just finally on this, or a couple of other points here. One is on the UN Charter. I think it is striking when we think about something like peacekeeping or war crimes trials that these ideas just don't appear anywhere in the Charter. So the Charter is an act of imagination, producing the Charter out of the sort of residue or remnants of the Second World War and the coalitions that built up around that, the United Nations being an idea before it was a thing, in fact. But then once the United Nations Charter is created, we end up with all these, what I would call acts of improvisation, which may also be acts of imagination around the text of the Charter. So if you ask the average person on the streets in London or Geneva, what does the UN Charter stand for? They probably say something like peacekeeping and war crimes tribunals, 2 things that aren't actually in the Charter. So there's an act of reading into the Charter that's an act of, if you like, political imagination and institutional improvisation that seems very important. But I think there's one final point I would make about the relationship between imagination and politics. So again, I think the tendency that we will both inevitably have is to choose projects that we like. So somehow to adopt the forms of imagination is also to adopt the content of an attractive or appealing politics. So the other example I was going to give of an imaginative text in international law was the famous Charles Worth-Chinkin Wright essay in the American Journal of International Law, Feminist Approaches to International Law, which was a pretty revolutionary leap for the field. There'd been an article on whales before, and now there was an article on women. I remember at that time this was regarded as a great revolutionary leap for international law, still is. But the examples we tend to give do tend to be or have a political content that we find already appealing. So one question is whether imagination here, or imaginative international law, is a sort of placeholder for a politics of international law that we like, or whether imagination is somehow politically indifferent or politically neutral. One can imagine acts of imagination that one finds vile or unattractive. And so that's certainly true of utopian politics. I mean, if we think about utopian politics today, many of us tend to look back on what are regarded as the great field utopian/dystopian projects and visions of the 20th century. So there's an allergy to utopia now, which I think itself is dangerous. There's an allergy to utopia in contemporary politics. So we need to think about imagination in that light too. We don't want to be surrounded by imagination and imaginative people all the time. That would be exhausting. Occasionally you need someone to say, hey, wait. This could be a disaster for the people of X or the projects of Y. This projection of your repressed subconscious is not what we want in the world today.
I think it's important to distinguish and to make this distinction. Gerry is approaching from the side that he speaks about political imagination primarily and the project of international law, which is, after all, the subject of this conversation. But I also have another sensibility that kind of literary imagination that has to do more with aesthetics, with the way we apprehend the world and we try to construct it and to imagine a different or an alternative to it. But I think it's important, regardless of which perspective you start from, to refuse this idea that the imaginative is opposed to the real and that the real is opposed to the fictional. It's not as simple as that, I think. To see these two things in juxtaposition, so positive law or utopian tradition and social idealism, Philip Allard style and the like, I think that most of the time, or at least the way I take it to mean, imagination and reality are somewhat complementary, if you like. I was struck once, I think I read something that Michelangelo is supposed to have said. I saw the angel in the marble and I carved it until I set him free. That's an extraordinary thing to explain what the imagination can make and what is the relationship of imagination to reality. And that makes me think I have a couple of things that sprang to mind as Gerry was thinking. Also, the way in which we conceive of the law, most of the time we conceive of the law as a set of rules, the principles and the institutions. And then the work of Robert Cover comes to mind, Norms and Narrative. And Robert Cover was there to remind us that it's not just the paraphernalia of social control, the legal tools we use. These legal tools are always embedded in a societal context, in a narrative. And it's the narrative that give meaning to what we do, to the rules we apply, to the ones we like, to the ones we refuse and dislike. And there, too, I think imagination is at play, because it allows us to see further, to see beyond, to see what embeds the law. And then another thing that I think Gerry is also very familiar with, because I think you have dealt with, is counterfactuals, which is also a nice way of playing with imagination and reality. I think you did something on counterfactuals at a conference that I could not attend, but I can tell you that I held a crowd for about 10 minutes talking about an imaginary, fictitious case that the International Court of Justice never decided. The decision on the merits of the Marshall Islands case. And the people in the audience were completely lost. They were looking it up on their portable phones.
I was taking notes with a view to describing it to my class the following Tuesday. So.
And Gerry was in the room, yes, indeed. And then after 10 minutes, I said, stop looking up for it. I just made it up. But I made it up for a purpose, because I wanted to let people realize that this actually might have happened. So that the International Court of Justice, rather than rejecting, refusing to exercise jurisdiction on the case, and refusing it on the grounds that if there was no dispute between the Marshall Islands and the other nuclear weapon states, in particular the UK, they simply made a choice. And to ask this type of counterfactual questions, what if, what would have happened if a court had decided a case, a lawmaker had made a different choice? I think that's also an interplay of reality and imagination, which is very useful. To have a clear idea about the world, about the choices that are made, about the actors that are involved, about the policies that are being pursued. So I think the interplay between imagination and reality is to me very, very complex. Surely it's not a juxtaposition, not necessarily a juxtaposition.
It could be that we have sort of strong and weak forms of imagination working in the field. So I would make a plea for the act of imagination involved in interpreting any legal document. I mean, I think somebody like James Boyd White would regard that as an act of imagination. So I have a friend who's a competition law QC in London. He was describing something really intensely doctrinal the other day over coffee. I mean, I'd sort of stopped listening after a couple of minutes, but then I sort of pricked up my ears at one point. He was talking about how he wanted to argue that a credit card wasn't really a credit card, something like that. I can't remember what it was, and I thought, yeah, right. This is the sort of work that somebody who's really engaged in the sort of micro detail of doctrine, the sort of thing we visionary, literary, imaginative types would tend to, or have a habit of disparaging, as in this idea that doctrinalists or people who deal with doctrine aren't somehow imaginative enough. But in fact, there's the application and mastery of a grammar and a technique combined with an active imagination involved in any hermeneutic process. So, and I mean, this is what happens in a way with chapter 6.5 of the Charter, this idea of developing a whole chapter right between chapter 6 and 7 by simply reading into the provisions of the Charter and then reading out of those provisions a power to send peacekeepers to Palestine or Kashmir in the 1950s. So these feel to me like acts of imagination, and yes, they do tend to, as you say, explode the relationship between the real and the imagined. And it could be to go back to an earlier point that I made, that we just don't want too much imagination. So since we're quoting Michelangelo and Nabokov here, let me quote W.H. Auden, who said, every time a tyrant cries, children die in the streets. And the idea there is that when imagination is taken too far, it becomes a form of authoritarian politics. It's the great dictator who simply imagines, and then the world becomes the material representation of his fantastic imaginary. But that's a very, very dangerous form of politics. One can see, forms of architecture that respond to that sort of politics in, for example, Romania in the 1960s and 70s. I don't like this suburb in the middle of Bucharest. Let's just clear it and build an enormous parliament, bigger than any parliament that's ever existed in the world. So some acts of imagination are just too big and produce life forms and physical buildings that are too big in the world. I was walking down the main street in Tbilisi about 10 years ago, and I came across the parliament building there. And I looked at it and I thought, there's something wrong with this building. And I realized the problem with it was about twice as big as it should have been. Parliaments are supposed to be big, but not that big. And the effect was slightly frightening, as if somebody's imagination had run riot.
Thank you. So I'm actually going to skip a few questions. So in case, no, that's good actually, because there are also answers to questions I didn't necessarily ask, which is great. So the next question is inspired by a quote from the film The Usual Suspects. If you haven't seen it, you must. If you have seen it, you should probably watch it again. So this is a quote by one of the main characters, played by Kevin Spacey, and he says at one point, "The greatest trick the devil ever pulled was convincing the world he didn't exist." And of course, that quote probably goes back to someone before Kevin Spacey, but most people will know it from the film. So the question is, do you think that lawyers are tricking everyone by trying to pretend that imagination doesn't exist in international law or doesn't have a place in international law? And I'm going to tag another question onto there. Is there something in international law that makes it resistant to imagination? And I guess if so, what is it?
I don't know. I think it's a widespread attitude still nowadays, and regardless of what Gerry said, and it depends on whom you hang out with, that imagination is still looked down upon by most lawyers, both domestic and international. It reminds me a little bit of the outright rejection that most positivist lawyers would make of the law and literature kind of sensibility in international law scholarship and in legal scholarship generally. This idea that literature is so far removed from our daily preoccupation about interpreting the law and applying the law, and I never quite understood how a postdoc could spend, I think entire months of his life, maybe years, to write against all of this by authoring this huge pamphlet, which is a huge book against literature. But be that as it may, I think, yes, there is some kind of negative bias which is still pretty much alive, which is a little bit funny because we do live in a kind of imaginary world. We have so many anthropomorphisms and reifications in international law. We live with these almost magical entities that are reified: the court, the commission. We do attribute anthropomorphic figures to the law that can be stretched, that may compel, that may direct, that has a will of its own. So it's a bit ambiguous because, after all, it's looking down upon imagination, not realizing that we are almost surrounded by an imaginary world. And law is I was reading an essay by Maximilian Danmar, who's a philosopher of law who teaches in London at Queen Mary. And he was making the point that the entire common law of negligence, after all, is based on an act of imagination. The famous case of Donahue versus Stevenson, 1932, the famous case of the lady who drank a bottle of ginger beer with the death's nail in it. And Lord Atkinson went to the Bible and to the parable of the Good Samaritan to develop the standard of care, which has become the rule of negligence. So it's not that imagination is not in the law, but it's still a widespread attitude to look down upon it. But why? Because I think we are still socialized that way, because we are trained to believe that imagination is a bad thing, that we have to do with the real world and with the mere facts. And then it becomes a habitus, and it becomes the way in which we operate as lawyers, and it becomes a second skin. So most of us, that they are not even aware that we have a bias against other forms of thinking other than what we have been trained to do and to believe. But there is a slightly darker side to it, because this is also a choice to stick to this kind of beliefs, to this kind of training, and to refuse imagination, because it is a political project, it is a political commitment to the status quo. It's also the acceptance of the set of beliefs that forms the system, and it's also some sort of self-empowerment of a community of individuals. So I think one has to be very careful when analyzing what are the reasons behind the bias, which is still widespread, I think, both in the profession and in the discipline, although things have changed a great deal in the past 20 years, that's for sure.
I think that's true. So at least one definition of imagination might be the idea of just taking some distance from present circumstances, or trying to force an estrangement of yourself from those circumstances. And I suspect that would be a literary and a political project. And I suspect too that it's not a very easy thing to accomplish these days. So my sense about the current political scene is that alternatives grounded in any sort of acceptable politics seem far and few between. So that almost any sort of politics, even a sort of soft social democratic politics inherited from Attlee Beveridge period Britain in the 1940s is being described as communist by newspapers in Britain. You know, thinking about somebody like Jeremy Corbyn, who's sort of discredited as a absolutely crazy left winger on a par with Trotsky or Lenin, but whose politics seem to me to be pretty mild and tame. So in order to take that distance, one immediately risks being described as utopian, and yet in order to critique the current order, this goes for law as well as politics, one has to take a distance. So Fred Jameson has written about this and says that the right position to take now is anti-utopianism. So we can't be utopian anymore, not after the 20th century, but nor should we necessarily be anti-utopian at every turn. We need to be very aware of the dangers of utopian thought and also the dangers of a relentlessly pragmatic anti-utopian thought that doesn't allow us to ever think beyond the contemporary or current scene. So this is something I think we can certainly do in international law. And I take the point that there might still be sort of clinging on to international law, this thing called sort of mainstream sort of rational international law. And I think the reason why international law took this anti-imaginative turn might be twofold. I was thinking about an essay I once submitted to a journal, and one passage in the essay came back saying, beautifully written, but is it relevant? And I've sort of framed that in my mind a bit. Is it appropriate simply to write nicely? Could I have written back to them and said, well, leave it in then in that case? You know, does everything have to be relevant? But there are two reasons international law might have taken this turn. One is a kind of Westphalian thing, and the other is a 19th century idea. So I think if we associate certain forms of imagination and utopia also with the centralization of authority or with something transcendental or religious, then we can think of the arrangement of sovereignty at Westphalia as being an anti-imaginative act, though I think it can be read as imaginative too. And certainly, if you think of Grotius as the great describer of the Westphalian settlement, then Grotius produced an act of imagination in his key text. In fact, he imagined international law out of nothing, according to the prevailing myths in the system, and we still live in that imagined world. I think it's very important to remember that. When we talk about Syria, for example, we're inhabiting that act of imagination. We talk about sovereignty, we talk about intervention, we talk about humanitarian intervention, we talk about civil war. All these categories that have imprisoned us when we think of almost any dispute in the world are inherited from this moment of imagination. Anti-imagination is how I would put it. And then in the 19th century, international law wanted to transform itself into some sort of science, because one of the anxieties international lawyers always have is that there's something unreal about everything we do. We're not sufficiently legal for the lawyers in universities, for example, and we're not sufficiently grounded in scientific truth or social fact or political life for political scientists, political theorists, international relations types. So we inhabit this unreal, spectral, anxiety-provoking region somewhere between all these various disciplines. And I think as a response to that, international law imagined itself to be a science. And as part of that scientism, it expelled acts of imagination, or it became unenthusiastic about what we're describing as a certain form of imaginative legal politics. And that might be one or two explanations for why we've got to this situation. But I do see a significant change happening here in the discipline. It partly depends what sort of conferences you go to, but sometimes it looks to me as if there are now two disciplines. Maybe we call it the imaginative international legal discipline and the and we'll call it the unimaginative international legal discipline. That's defamatory, but the anti-imaginative international legal discipline. So you go to conferences, two conferences, one at the Foreign Office and one at Harvard, and you feel like you're actually encountering a wholly different field, as if you've turned up at a microbiology conference here and a biochemistry conference here. And okay, there's some vaguely scientific overlap between those two fields. No doubt you'll correct me on that. But the fact is, they feel, they have the texture, they have the linguistic tics, the discursive categories of two different fields. So I think that's a rather peculiar thing that's happened to the field of international law since I've been studying that. I find some of the ideas that come out of international law almost unrecognizably banal now. I can sort of put it in slightly contradictory terms.
Great. Okay. And can I just ask, banal, do you mean that in a negative sense or no? I mean, because it comes across to me as something that's
I was just being a
not
smart
positive.
aleck here, really.
That's not a question that I had prepared, but it's just.
It's a good question. International law has sort of skirted with banality. So one problem might be that international law, in grounding itself in this scientific move in the facts of social existence, may have rendered itself banal by merely describing, I'm not using it in some Arendtian sense here, by merely grounding itself in that existence. So that's always a risk with the move towards science, the move towards sociology, the move towards various positivism, neo, and otherwise, that you end up flirting with forms of banality.
I'm not sure what the people that do these kind of things, they would have looked at themselves as doing banal things. But I want to comment further on this kind of attraction that international lawyers have for science, which is not new. We always like to look at ourselves as scientists or as scientists doing something serious. And I think this has taken the guise of the form nowadays of this turn to empiricism. Resorting to empirical studies. And yes, I quite agree, describing the world, measuring the world. I think it's relevant to share with the crowd the anecdote that Anne and I lived a couple of years ago, was it really 2 years ago, when we went to a conference together and we submitted a paper on emotions and international law, and particularly on fear and international lawmaking. So we shared this with an audience of people who had slightly different sensibility, and at the end of the conference we were asked, okay, but how do you measure emotions? And I took the lead in answering. I said, I don't do measurements. I try to get people to think. But the crowd looked very unpersuaded by my remarks, and they still wanted me to do the measurements. So, well, what is the risk, I think, that Gerry was hinting at, is that by this turn to empirical studies, empirical studies are extremely important. I mean, they can substantiate more credibly certain legal claims. They can be used actually to shed light on certain things, but they can't be taken as the alpha and omega of explaining the world as is. So that's the risk that I see in it. And imagination is not incompatible with empiricism, because it depends on what kind of questions you ask, and then what kind of questions or hypotheses you take to be tested. So I think there too, imagination can be of some help, because data doesn't speak by itself. I mean, still have to decide what kind of questions to ask about the world, and then you may still test some of them by empirical means, but certainly not everything. And what I found extraordinary is that even scientists clearly admit of the importance of imagination. I mean, Einstein has some incredible quotes about the importance of imagination, which really makes science advance by creativity. Imagination is more important than knowledge in order to promote scientific progress. So it is funny, because we're attracted towards this an attainable goal of science, but science itself, has doubt as its companion. So I found it a little bit exaggerated, this turn to empiricism, whereby we pretend that we can explain the world on this basis only, while I acknowledge that this can be useful means to do certain things.
I also think that students come to international law expecting some imagination, and that we ought to deliver it. People who I did when I was choosing subjects, I chose international law because I had written on my personal statement, after all, that I wanted to change the world, and it didn't feel to me as if snails and ginger beer bottles were going to change the world, though they may have changed. Donahue and Stevenson may have changed the world in some respects, but it didn't seem immediately apparent that the study of contract law or tort law would engage me in some great imaginative project to transform global affairs. And so international law, already advertising itself as global, it was after all international, just seemed inherently glamorous to me. It seemed to have already somehow contained in its own name the possibility of some sort of radical transformation. International law. You hear people invoke it all the time. It sounds like a good idea. And it also sounds like the sort of place that would be fertile territory for acts of imagination after the relentless accumulation of technical expertise and knowledge that the rest of the law program seemed to offer. It often offered a lot more than that, as it turned out. But that's what I understood the picture to be early in my career. So I think students come to international law. I've actually called international law in one of the courses I teach at LSE the last of the humanities. If you think the humanities are being somehow squeezed by the professionalization of education or the technicalization of education, if people who might have done English literature or Scottish literature or fine art but got marks that were too high at high school and ended up doing law degrees instead, are a loss to the arts, are a loss to literature, then one of the places they could go to in a law degree to get some of that, get some of your marvelous sort of literary sensibility, is in international law. It seems international law could be a host of that. Could be one of the great contributions international law makes to knowledge in the 21st century by being the last of the humanities, or what Frederick Jameson has called an enclave, a place where one can go to escape the oppressive metricization of contemporary life.
Okay, so let me sort of latch on to that point on education, because I think it's a really important point to spend a little bit of time on. So when I think about imagination, I think about children. So as children have huge imaginations, and I think quite often it's expected that you don't have that sort of childlike imagination anymore when you grow up. And when I think about children, I also think about education. One of the comments that I get with every evaluation of every course, and it's always a couple of students at least who'll say this anonymously, of course. I've never had it said to my face, although I would welcome students telling me to my face, that they were disappointed in the course because the professor didn't give us any answers. You didn't give us the answers to what's the answer to whatever course, whatever topic of the course that I'm teaching. And it did, and especially sort of, I guess the first time I saw this comment, I was quite in despair. I thought, but I never said that I was going to give you all the answers, and that's not the point, and you're graduate students, so you shouldn't be expecting me to give you the answers of sort of how the world works. But it does make me wonder also about education prior to coming into law school, or prior even to becoming a graduate student in law. So what are we teaching our children in primary and secondary education before they even make the choice of wanting to become a lawyer or an international lawyer, for that being? So I mean, when I think of imagination as being something childlike or childish, it's not necessarily a compliment, I think, to anybody who is not a child. So is there something about our education system that's also preventing our imagination before we even enter the world of international law? And in relation to that question, what role does imagination play, or should imagination play, in your view, in the academic world?
That's way outside my range of expertise. I have to say, the idea of what we should do to educate people before they come to, I mean, it's a good question. There's a passage in the Bible about putting away childish things. And I was always very struck by this passage when I was growing up, studying a sort of Presbyterian church in the north of Scotland. This line, because I felt reluctant to put away childish things. It just seemed somehow too harsh and Calvinistic for my purposes. And I mentioned it to somebody, a professor who I studied under, Tom Campbell, a Scottish philosopher, who said you have to distinguish between childish things and childlike things. I think that was a very important distinction. Maybe it is important to put away childish things, childish emotions, childish grievances, and so on. But to go back to Nabokov again, to hold on to something childlike in our perspective on the world. I mean, we know that children are trained out of caring for other people. Very often adults train children not to care too much because caring is so problematic. So when a child demands that you do something about a homeless man on the street and you offer 17 explanations as to why you cannot do anything, or another adult says that they can't even hand over money because they'll use the money their own. We've got all these explanations for not being childlike. I think it's important to hold on to that childlikeness, I would put it. Interestingly enough, and your question about childlikeness and childishness got me thinking about the way in which international lawyers themselves have been positioned as childlike in relation to other disciplines. So I remember Philip Bobbitt in that book of the sort of history of the diplomatic system, starting with the Italian city-states, talks about international lawyers with their boyish fantasies about Kosovo, and that really, it struck me as interesting that to apply international law to the problem of Kosovo seemed, from the perspective of somebody with a very sort of classically realist perspective on international diplomacy, as sort of boyish or childlike. And of course, there's a whole history in international law, especially 19th century international law, describing whole states as childlike. So James Lorimer, the Scottish international lawyer, described a whole bunch of states as possessing nonage or being infantile and so on. So he arranges states into childlike states, or he probably means childish states, and states that have reached somehow full maturity. Well, we still live in that world. I mean, the whole developmental ethos is structured around the relationship between maturity and childishness or childlikeness. So, I mean, it's an important question to which I have absolutely, no adequate answer at all.
Neither do I. I mean, after all, we are among the two most imaginative people, so we are characterized by not providing any answer. Thank you. So, no, I think it's a good point. Again, coming from that kind of literary or sensitivity, I do like the idea that it's good to maintain some childlike reactions about everything, including international law. That capacity to be stunned at simple things, at trivial things, as Gerry said, that sense of awe that you can see in a child who looks through the window at the snowflakes, which, we simply acknowledge as some banal natural event. That kind of capacity of, developing sense of awe, émerveillement, I think it's a fantastic thing, which is very useful because it allows you also to capture in space and time moments that have meaning. And we tend to lose it over time. And we tend to lose it over time also because of the educational system, probably, which we go through. Not necessarily depends on where you are, it depends on where you are being educated. I think it's very difficult to make generalization. But one thing I think is fair to say, you cannot make abstraction from the culture of the times. And the culture of the times is clearly a culture in which there has been a shift from normative to scientific expectations. Technology, whatever can produce an immediate practical utility is praised and commended. And whatever has no such practical utility is vilified, including the humanities. So I like the idea that Gerry put forward about international law as the last bastion of humanities in the legal curriculum. I think it's a very committed and interesting project to which, we should all commit ourselves to counter this wave of scientism that is taking away that kind of childlike capacity to see a moment of beauty in the world that surrounds us. But I want to make a point about education, which I think is important since we are hosted by an institution of higher education. Most of our students are graduate students and so on and so forth. So I think there is also a certain type of mantra which is imitated by institutions of higher learning worldwide. And the mantra, which has to do with the contemporary culture, is, certainly not one that favors the kind of conversation that we are having today. It's rather an invitation, to make an investment in a vocational training, in the acquisition of practical skills that you will put to work for whatever purpose. And humanities have no place in this. And then we lose the imagination, and we lose also on the way the capacity to get stunned, which I think is important, particularly if you're an international lawyer, because there is so much material to play with. To use again James Boyd White's idea of using imagination in law, it means to deal with inherited materials against inherited constraints. It's a beautiful image because it means that it's not that you can do whatever fancy, whatever whim, and you may smuggle it as if it is an interesting piece of imagination. After all, you inherit materials, you inherit a discursive policy, you need what is credible to be said in a certain discipline. It depends on what is perceived to be the policy of the discipline. So it's not anything goes, not at all. But at the same time, it's also about the capacity to refuse some of the constraints, of the limitations, of the rigidities that may come with it. And I think that's what we miss, to give a sense of opening up to alternative choices.
Good. I do have more questions, but yeah.
As you wish.
Yeah, okay, great. So we have just about 18 minutes left. So what we'll do now is open up for questions from the audience. So if you could, there's a microphone that's going around. If you could maybe just say who you are and what you do so you have an idea of who's asking the question.
Thank you. The name is Miroslav Matsura, formerly with the UNEC demographer, not a lawyer. But it was an interesting and indeed provoking presentations that we listened tonight. And although not in the field, I was sort of induced to ask a couple of questions. Although, as Professor Simpson said, it may be dangerous to invoke examples of imaginative international law. Two prime examples have been cited which go back to the middle of the 20th century and earlier: the Charter and the League of Nations. Nothing later. So questions arise in my mind. Are there no people of imagination to add to the international law at the end of the 20th, the beginning of the 21st century? Do major world upheavals perhaps led in the past to the imaginative efforts at further shaping international law? And are there constraints that prevent sort of imaginative efforts at continuing with the evolution of the international law? And a sub-question, which pertains in a way indirectly to Kosovo that you, Professor Simpson, mentioned. Kosovo was, if you will, or the NATO bombardment of Serbia and Montenegro was the first, to my knowledge, case of the humanitarian intervention, which was then sort of codified into R2P, responsibility to protect. I don't know what the status of R2P is, but the question is whether that is an imaginative development. Thank you.
Maybe if that's okay for both of you, we could collect the questions and then get a response. Yeah. Yeah.
Hi, my name's Abhimanyu. I'm a PhD candidate here. I was wondering if you might be able to say something about the relationship between imagination and creativity. Are they the same? Are they different? Are they different degrees of the same phenomenon? And I asked that question for two reasons. And the first is that a lot of the examples of what you cited as imaginative acts, I would intuitively label as creative acts. And the second reason is that creativity, I think, at least the intuitive definition I'm working with, is something that is very prized amongst lawyers. But as one of you said, imagination is something that's looked down in amongst lawyers. Thank you.
Should we take one more? Is that okay? Yeah.
Hi. I was wondering how you would address criticism that international law is imaginary in and of itself. I've heard, especially in the American legal tradition, like kind of very dismissive feelings towards like Human Rights Committee jurisprudence or just like the UN committees in general. And so I'm just curious how you'd feel about that.
Great. Okay. So we'll let you respond to these, well, more than 3 questions.
Yeah. Like, can we go with these?
I'll take the creativity question that Abby asked. I told you I'm not good at defining things, but to me, creativity is triggered by imagination, and imagination is somewhat nurtured by curiosity. So that's the link. Just to give you an example about how this may play out, and I think I'm not sure whether you're familiar with this short novel by Edgar Allan Poe, The Purloined Letter, The Stolen Letter. So it's a very powerful short story that it's about a letter which gets stolen from some, aristocrat or royal member of the royal family. So it needs to be retrieved immediately. It may it may trigger a war. So the police finally gets to find out who the thief is. And, drawing some inferences, they know for sure that the letter must be in the apartment where this magistrate D, I think, is called, actually lives. So the police storms into the apartment and they start searching this letter. And they don't find it, and they keep searching. At some point, even more units are dispatched to do this. They open, everything in the house, they tear everything to pieces. They don't find the letter, but they're sure it's there. And then all of a sudden, this private detective, which I think is the predecessor of Sherlock Holmes, which is called Dupin, all of a sudden says, okay, give me a little time and I'll find it. And he finds it in just a few minutes. Why? Because the letter was in a rack, first sight, very conspicuous, at the entrance of the apartment. The problem is that it had been folded differently and that the seal on the letter had a different color than what the police was looking for. So it's a powerful thing because it means that you can only find, you can never find what you're not looking for. So the police could double the efforts, but they were looking for a particular type of letter. They had no creativity, they had no imagination. And it was easy to find it once you had the capacity to imagine that this could have taken a different form. And it was right there on the rack. So I think that's an example of the kind of mental activity that is demanded of imaginative international lawyers, I would suppose.
Yeah, so in answer to this question that this gentleman up here asked, I think that's right, that since 1945 we haven't had what you might think of as one of international law's constitutional moments. So when we list the great moments of international law, we tend to think, Westphalia, maybe Utrecht in 1713, maybe Vienna 1815, Versailles, San Francisco 1945, Tokyo Berg 1946 to 48. And then we run out of steam a bit, and it may be because it's like your purloined letter. We're looking for the wrong thing. We're looking for something that looks like the UN Charter. We're looking for something that looks like the League of Nations, and we won't get that now because there isn't the same faith in public-spirited international institutions. That might be one answer. I mean, of course, people will say, what about the Law of the Sea Tribunal, or what about the International Criminal Court? And I take the point. Those were institutional projects that required a degree of imagination, but they didn't have the global reach or the substantive scope of the League of Nations and the UN Charter. So another answer would be to say, well, imaginative legal politics have gone elsewhere, or the people that might have engaged in those politics have gone elsewhere. They've become more interested in working for, banks or NGOs, their hopes and ideals and acts of imagination have been privatized, as it were. Might be one answer. That people don't go to the UN with the same sort of expectations they might have had in 1950 or 1960. No one can recapture the Geneva of 1920. As someone once said, what was once a promise is now a routine. So there's no longer quite that degree of hope and energy around international institutions. Maybe it's just not the moment for international institutions, and if we're looking for hope, idealism, imagination, we're looking in the wrong place. But I don't mean to suggest that it isn't around. I mean, clearly there's a generation of young people who are doing remarkable things in the world and will do remarkable things, just as remarkable as our generation, perhaps more so. So I just think we need to be careful to go back to Edgar Allan Poe about where we look. I don't think R2P is it. I think it was one of the most disappointing legal political projects of the late 20th, early 21st 21st century seem to me to be just a refurbishment of 1970s ideas of humanitarian intervention. I'm not even sure that Kosovo is a good example of that. So I wouldn't put R2P into that basket. It's just too much of an anticlimax to count as a great sort of imaginative lead. But I absolutely take your point. I think it's an interesting one. You know, where exactly have things gone since Nuremberg, Tokyo, and the UN Charter? So you've dealt with the creativity, imagination point comprehensively. I have nothing to add to that. But to go to your point, yeah, I imagine that is the view in the United States. But we're in the age of fantastic politics anyway. Look at Brexit. I have to mention Brexit. It's obligatory. I think there's a contractual obligation on all British people to mention Brexit and hold their heads in their hands in despair, which I won't do. I'll spare you that. I do that in my hotel room later. But that or Trump's fantastic projections seem to me to be very ungrounded, both in a psychological and a political sense. So all I would say is that poor old international law is standing up pretty well to all these other fabulous projections in the United States. Most of US politics seems to be founded on fantasy at the moment. As we know, there's a suspicion of expertise, there's a suspicion of the very facts and figures we've disparaged slightly here. There's a suspicion of truth itself. So it's hard to see that as having much of a basis in anything one might call reality. So this is international law's great moment. International law's like that too. So in a way, international law can join in and be the yin to Trump's yang, or to be a form of imaginative politics that we can attract people to, given that they seem to be suckers for imaginative politics in the first place. Let's just show them a more appealing version of that particular global fantasy. So that's what I would say in response to that.
If I might add, I entirely agree. I think that international law suffers regularly from many things, but also from one. It makes me think of Jacques Lacan's mirror stage. And so when the child looks at herself in the mirror, and for the first time she has the perception of wholeness, and so the mirror becomes almost an unattainable goal, and it creates also anxiety. And we have often used as the mirror a representation of international law, the domestic sphere, the wholeness and the enforcement and everything that is guaranteed under certain mechanisms. But this is doomed to failure. I mean, we have to move ahead of the mirror phase. We have to grow up, and I think there is potential. I mean, I would like to say, look at the potential good in international law and use your imagination to set it free, like Michelangelo. There is potential for imagining a different international law or new or something. But that potential, that's the raw materials which imaginative projects must work on.
Okay, I am afraid part of being a moderator is sticking to time, so I'm afraid that we don't have time for another round of questions, but I am going to use or abuse my position up here to ask a final question, because I do want to give you hopefully about a minute each to give us your final thoughts on what future is there for imagination in international law in 1 minute.
Well, it's got a great future. Clearly, there are so many people engaged in what they imagine to be imaginative legal politics, and if international law is what international lawyers do, then a lot of people are doing what they think of as imagination, and that's good enough for me at the moment.
I don't know how to conclude. I would invite everybody to live imaginatively, both in their personal lives and their professional life. That helps a great deal, also with political projects.
All right, thank you very much. Thank you to the audience. I'm sorry we didn't have time for all your questions. I'm sure there are many, many more. Thank you very much to Gerry and to Andrea for being here and for your time. And I hope we'll continue this conversation and these imaginations. Thank you.